All right, friends, let's go ahead and get started right at the 7 o'clock hour. Welcome, friends. Good to see everyone. For those of you who couldn't join us last time, I'm Kristen Collier, and on behalf of the University of Michigan Medical School Program on Health, Spirituality, and Religion, and along with Dr. Joe Bufiel, who is with us tonight, representing our co-sponsor, the University of Michigan Burr Oak Foundation. We are thrilled to be hosting you for Seminar 2 of 4 of our 4-part series with Professor Carter Snead on what it means to be human. Tonight's topic will be on the topic of abortion. Our format will be similar to last month's session. Professor Snead will give some opening remarks for about the first half of our time together, and then we will discuss the topic using your questions for our second half. Before we get started, just a reminder that we will be collecting your questions using the Q&A function, not the chat. We will try to prioritize questions from students, learners, and trainees. Please send the questions at any time during the presentation as they come to you, but we will be going through the questions after Professor Snead's formal opening remarks. I formally introduced Carter last time, but for those of you who are unfamiliar with his work, he is a professor of law and concurrent professor of political science and the director of the Nicola Center for Ethics and Culture at Notre Dame. He is one of the world's leading experts in public bioethics, and our seminar series is covering the material in his latest book, What It Means to Be Human, The Case for the Body in Public Bioethics, which was published in 2020 by Harvard University Press. Now onto our subject tonight, the topic of abortion. As Carter writes in his book, quote, "Abortion involves complex questions about the meaning and value of human life in its earliest stages. Questions of parenthood and procreation, the nature of killing and letting die, the ethics of medicine, the definition of health, the contours of freedom and autonomy, the demands of justice and equality, and the concept of human dignity. It is the pristine exemplar of a vital conflict, a zero-sum struggle involving literal life and death decisions. And it remains one of the most bitterly contested public questions in American life," end quote. I thank all of you for being here and realize, as someone myself who has had wildly different views on this subject in my adult life, how challenging this topic is to engage with and discuss. I know that the views of you, our attendees, also vary on this topic. And our goal tonight is to listen to one another and encounter this topic thoughtfully, and we appreciate Professor Snead's time in helping us do so. I'm going to turn the floor over to Dr. Bufiel, the president of the University of Michigan Burr Oak Foundation, to say a few words to help us ground our discussion tonight. Joe?
Thanks, Kristen. We're really delighted to welcome you to this, our second of 4 seminars on what it means to be human, implications for public policy and bioethics. And special thanks to Professor Snead for making this seminar a really great event for the University of Michigan. His talk from last month is now up on our website, and I'd encourage all of you to review his presentation. As Kristen mentioned, today, he'll be addressing the difficult subject of abortion. Perhaps more than any other issue, abortion defines the great fault line in public bioethics today. Polls suggest that most Americans take a middle-of-the-road position. About half the country feels that there could be some legal justification for abortion under certain limited circumstances. A fourth say that it should always be legal, and a fourth that it should never be legal. What almost everyone seems to agree on is the science. Abortion ends the life of an individual member of the human species. So the tension lies in whether or not that human being can be considered a person, a bearer of rights, specifically the right to life. Should we confer the rights of personhood on that preborn member of our species? In the classical Western tradition, the answer is yes. Every member of the human species can lay claim to the right to life from the moment of conception. Liberal progressive arguments would claim that no, personhood ought to be based on some acquired functional attribute present in a particular human being. Things like self-awareness, the capacity for self-determination, etc. Lacking those capacities, no right to life exists. It's interesting that one of the most effective critics of the liberal progressive arguments for abortion is the utilitarian philosopher Peter Singer from Princeton University. In his book, Writings on an Ethical Life, he challenges most liberal justifications for abortion. For example, Singer argues that the moment of birth should not be the point at which killing the fetus becomes unacceptable. Aesthetic arguments against abortion, in his words, it's harder to agree to the killing of a being that we can all see and hear and cuddle, ought not to ground our ethical thinking. Viability arguments are inadequate because a viable fetus in the 21st century would not have been viable in the 16th century, and a viable fetus in modern-day Manhattan might not be viable in today's Mogadishu. Justification of abortion, claims Singer, should be grounded on metaphysics and not on happenstance regarding where and when the woman conceives. He also rejects the argument that restrictive abortion laws will drive abortions underground. That, he notes, is an argument against abortion laws, not an argument in favor of the moral legitimacy of abortion considered in itself. Singer also argues that total dependence of the fetus on the mother for existence is not a situation that gives the mother sovereign rights of life and death over the child. He also criticizes the standard feminist claims that the fetus is part of the woman's body for her to deal with as she chooses. So even though he attempts to expose from within his philosophical frame of reference the weaknesses of liberal arguments for abortion, Peter Singer remains one of the most notorious intellectual advocates of abortion and infanticide. And in making his case, he helps focus our attention on where the rubber meets the road in the abortion debates. That is, the denial of human exceptionalism. He does not deny that the fetus is a human being. He rejects the idea that merely belonging to the species Homo sapiens is sufficient to make one a person. The Western tradition, which exalts the dignity of human beings as created in the image and likeness of God, is for Singer an irrational prejudice grounded on illegitimate religious claims. For him, placing human beings in a different category than, say, iguanas, pigs, or chimpanzees is irrational. It is speciesism, an unjustified discrimination akin to racism. By rejecting the notion of human exceptionalism, he also discounts any possibility of human transcendence. What makes any animal special for Singer is consciousness and autonomy, self-awareness and self-determination, which humans do not possess until well after birth. And so abortion and infanticide should not be morally problematic. As we've learned from Professor Snead, these materialist utilitarian positions do permeate public policy in the United States and make it very difficult to develop the networks of unconditional and uncalculated giving and graceful receiving that sustain civil societies and make human flourishing possible. We at the Burr Oak Foundation are thrilled to welcome Professor Snead to our second seminar to discuss the anthropology of abortion rights. Thank you.
Thanks, Joe. Carter, are you ready?
I am now that I'm unmuted. I'm ready. I was
Right.
not ready when I was muted, but now I am.
Fabulous, fabulous. Take it away.
Yeah,
Thanks.
so it's great to be back with you. This is such a wonderful program. It's an honor to participate in the Burr Oak Foundation event in conjunction with Kristen's wonderful center and program at the University of Michigan Medical School. I'm going to share my screen with you in a moment here, right now. And I'm going to shift the view to a so you can to the slideshow view. I don't know, I'm narrating everything that I'm doing, but nevertheless, that's what we're doing. So, all right. So today's talk, it builds upon the talk from last time. It is arguments and discussion drawn from my book, which both Kristen and Joe very generously mentioned. What it means to be human, the case for the body in public bioethics. And if you were to have the book, this is drawn, and it will sound familiar to you because it's drawn very heavily from chapter 3 of that book, which is one of the 3 vital conflicts that I take up in the book to test my hypothesis about the role of anthropology and law and public policy and public bioethics. The other 2 of which we'll be discussing in the weeks to come, namely the law and policy concerning assisted reproductive technology, and then finally, law and policy that touches and concerns end-of-life decision-making. But so for those of you who might not have been with us last time, what I'd like to do very briefly is to recall the fundamental claims of the book, and then just to very briefly recapitulate the argument from the book. So the claims of the book are, first of all, methodological, and then secondly, substantive, and they are obviously deeply connected to one another. Methodologically, I argue that the richest and most potent method of analyzing matters of public bioethics, that is the law and policy relating to the governance of science, medicine, and biotechnology in the name of ethical goods, is through what I describe as an inductive anthropological inquiry. And despite the sort of technical sounding nature of that expression, it's really very simple and straightforward. The question I ask is, I take the law as it is, and I ask the question of what vision of human identity and flourishing is it that anchors and animates the law and policy in this particular area. And I'll remind you in a moment why I think that's the right question to ask for the richest and deepest understanding of any area of law and public policy, but especially public bioethics. And when you take that analytic framework and you apply it to these vital conflicts, one of which we'll be discussing this evening, what comes to the surface is an anthropology that very closely resembles what philosophers and social scientists have described as expressive individualism. And I argue that that is not a suitable foundation for law and public policy, certainly not in the area of public bioethics, because it's a vision that cannot and does not make sense of the lived reality of human embodiment. That is the fact that we are bodies, we negotiate the world as bodies, we encounter the world around us and one another and even ourselves as bodies. Of course, bodies that are intertwined and integrated seamlessly with a mind and an intellect. But what defines us, I argue, is not merely our will or our mind, but instead the dynamic union of both, which includes necessarily our existence as embodied beings. And by virtue of our embodiment, there are certain kinds of inexorable entailments, such as vulnerability, being embodied beings in time that are subject to disease and corruption and aging and injuries and so on. We're vulnerable, which stand us in sort of a relationship to one another of reciprocal dependence, and we're subject to natural limits. The vision of expressive individualism, that is the anthropology that underlies many important areas of law and public policy, doesn't take this into account, doesn't understand people through this lens, and therefore are not a fit foundation for public bioethics, for reasons that I will briefly, again, recap momentarily. Today, my talk is going to be about a very concrete subject. It's going to be about the issue of American abortion jurisprudence, the law and policy of abortion in the United States of America. And let me say also, my analysis and what I'm going to say about the law of abortion in America is not commentary about individual decision makers. It's not commentary about people who seek abortions. It's not commentary about people who perform abortions or people who oppose abortions. It's about the assumptions that the law operates according to, involving what and who persons are and what constitutes their flourishing. Now, that's related to the question of individual decision-making, but it's one step removed from it. So I don't want any confusion about the comments that I make, the vision of human personhood and flourishing that undergirds the law and policy of American abortion law. That is not necessarily the vision of persons that are held by the individuals who make decisions, either to get abortions, to avoid abortions, to perform abortions, and so on. So this is, at bottom, an argument about the law this evening. It is not an argument about people or what people think. It's about what the presumptions of the law, the doctrines and policies, and in this case, Supreme Court judicial decisions about what human flourishing is and what human beings are. Okay. And my argument is that American abortion jurisprudence is grounded in the anthropology of expressive individualism. It's forgetful of the body in the way that I just described, and thus it's incapable of protecting or promoting the flourishing of mothers, babies, and families in light of their genuine needs as embodied beings situated in community with one another. So, my talk, again, the chapter in the book is literally 75 pages long. So there's no way that I can do justice or with sufficient granularity talk about all the arguments in the book, which depend on a very long and detailed account of the history of American abortion jurisprudence beginning before Roe v. Wade, but focusing most intently on 1973 unto the present day. And if any of you are interested in learning more about the law and public policy of abortion generally, I would commend the chapter to you just for the descriptive account of it. It's not, if you're not persuaded by the normative arguments, that's fine, but the descriptive account might be interesting, especially in light of the Dobbs case, which the Supreme Court granted cert in this past year, which is the most important case before the Supreme Court on the question of abortion rights and all the interests that surround that since 1992, since Planned Parenthood versus Casey. So it is an extraordinary watershed moment for the court to grapple with the question of abortion and law in a very direct way, and the relationship between abortion and the Constitution, if there is a relationship, and principles of stare decisis. I'm not really going to talk about that in my prepared remarks. I'm happy to talk about it in the question period, but the description, the narrative description of abortion law and policy in the book might be useful and helpful to people who want to understand the issue in the Dobbs case and to formulate a view as to how that case should turn out. Okay, but that's not what I'm going to be talking about in my prepared remarks. First, I'm going to be focusing on the jurisprudence of abortion, primarily on Roe v. Wade and Planned Parenthood versus Casey, and I'm going to apply what I have already described as an inductive anthropological analysis to those judicial precedents and discuss what I find and offer a criticism of the anthropology assumed and really responsible for American jurisprudence, I would argue. But before doing that, I'm going to very briefly recap what I mean by an anthropological analysis of law and policy and why that I think is the most appropriate means or way into these questions. And then I'm going to talk very briefly about expressive individualism and why I think it's an incomplete conception of the self that is forgetful of the body and problematic as a grounding for law and public policy. So this won't take very long, don't worry. Law and anthropology, and again, I covered this last in our last discussion, but it's worth recapitulating. First of all, for those of you, especially those of you who are not trained in the law or studied the law, or even for those of you who have been, it's important to remind ourselves that law itself is irreducibly normative. There is no way to understand the law that is not rooted in a particular vision of morality or ethics or the conception of justice or freedom or autonomy or equality. Law itself, at bottom, every law, no matter what the law is, no matter how mundane the law might be, aims at a particular normative good to be advanced or a particular harm or set of harms to be avoided, deterred, or even punished. And situated as it is, oriented towards these particular goods, whatever those goods might happen to be, the law reflects the goods that a given people hold dear and the harms that they seek to avoid. And as I said last time, Oliver Wendell Holmes is not someone I normally cite for bioethical wisdom. Usually to the contrary, I think he made some very serious errors in his judgment and his arguments over the course of his career, certainly as a Supreme Court justice. I'm thinking of the Buck v. Bell decision on involuntary sterilization. But nevertheless, he was exactly right when he said that law is the witness and external deposit of our moral life. You can learn a lot about a people, what they care about, what they're afraid of, what they aspire to, by analyzing what is permitted, prohibited, encouraged, punished, etc., by the mechanisms of the law. But law also is not merely reflective of the given norms of a particular polity. It also shapes, for better or worse, public attitudes and teaches about what goods and harms are fitting, what justice means, what freedom requires, what equality entails, and so forth. People take their bearings, their moral bearings, their ethical bearings from what the law prescribes. And that is another sense in which the law is, as I say, for better or worse, richly pedagogical, but always normative. So why do I argue that an anthropological analysis is the appropriate way into these questions, especially involving public bioethics? Well, it's very simply stated, as I mentioned last time, law at bottom, in addition to being normative, in a sort of more limited sense, aiming at goods to be pursued or against harms to be avoided, law is most fundamentally about and for the protection of and flourishing of persons. That's what law is for. At its deepest, most normative level, that is what law is for. It's to protect people. It's to promote their flourishing. That's what law is supposed to do. That's its primary animating rationale. And accordingly, it unavoidably rests upon mostly undeclared conceptions of human identity. In order to promote the flourishing of persons or to protect persons, you have to know, or at least operate from a set of assumptions about what persons are. And I don't mean in the sense of when life begins, when the life of the human organism begins, although it's connected to that question. I'm talking about what are the indisputable class of individuals that we describe as persons. What are they? Who are they? What in what does their flourishing consist? These are the questions that the law has to assume answers to if its doctrines, principles, and policies are going to be anything other than arbitrary and capricious. So, accordingly, because law rests on these usually unstated conceptions of what persons are and what their flourishing consists in, the richest and deepest understanding of law is anthropological. It's through analyzing the vision of human identity and flourishing in which the law is anchored, by asking the question, who and what does the law assume a person to be? Now, when we discussed this issue last time we got together, I argued that one version of anthropology, one vision of human personhood and flourishing, is what Robert Bellah described, a social scientist, Robert Bellah, who the author of the classic Habits of the Heart, described as expressive individualism. And then, of course, philosophers Charles Taylor, Michael Sandel, and others pick up on this idea and related ideas to mount a critique of this particular vision of human identity and human flourishing. Well, what's wrong with expressive individualism? What exactly does it? Well, before we say what's wrong with it, let's say what is it? What is its version of human identity and flourishing? Well, first of all, it conceives the person as an isolated, unencumbered, atomized individual self. The fundamental unit of reality is the individual, and it's not just the individual. It is specifically the individual will. It is the individual mind. It is the capacity. It is the cognitive faculty that has the capacity to make choices and to chart a future of its own volition. And that is what defines the person. The person is individuated, radically individuated. The number is one. And the idea is that the person is defined by his or her will. Everything else, including the body, is merely instrumental and can and should be harnessed to pursue those projects that emerge sort of endogenously and are adjudicated by the will. The person is defined as an individual chooser or consumer, and human flourishing, as I've already alluded to, is the pursuit of those projects of your own construction, the imperative to live your own originality. The person is conceived, in the words of Michael Sandel, as a self-originating source of valid claims. Flourishing is accomplished through the internal reflection on the interior sentiments of the self, irrespective of our relationships to others, irrespective of our traditions or the community in which we find ourselves situated. It is abstracted from all those things. We simply meditate on the inner voice and the interior of ourself, and then we, from that reflection and introspection, generate a kind of future-directed plan of our own devising our own authentic truth, our own originality, and then we chart our life course accordingly, using everything else around us as a kind of instrument towards that end. It is a vision of the person and human flourishing that is profoundly anti-teleological, meaning that it does not take seriously the external givens that we encounter, the physical world around us, for example, as normative or as a guide to negotiating the world and to pursuing our own future-directed plans. Only the unique and original inner voice is definitive and normative. We can't know what we're supposed to do or who we are by looking around us, by studying the physical realities that we see. The only voice that's dispositive on those questions is the voice that comes from inside. There are no unchosen obligations in this anthropology, in this worldview. The only obligations to which I am bound are those which I freely assume. It is the realm of contract. It's the realm of transactions. It's the realm of consent. There are no constitutive attachments. There are no natural relationships. There are no situational circumstances that can bind me to do anything that I don't freely choose to do, and certainly not to make sacrifices for another person. In fact, personal relationships are viewed through a lens of my will and my desire and my choices for the future. They're instrumental and they are transactional. That includes not just personal relationships, but that also includes familial relationships. And individuals in this realm encounter one another as isolated wills, as isolated, atomized individual wills that can, of course, collaborate when there's mutual interest afoot. But also, and perhaps even more commonly, they have to overbear one another, because this world is certainly not characterized by collaboration. In fact, one could say that it's characterized in some ways by strife. It is a world of atomized individual wills seeking to pursue their own destinies. And if they encounter an obstacle, including another will that seeks to obstruct them, then they have to overbear that will. And ethics through this lens is reduced primarily to the good, to pursuing the good of autonomy. It's the highest good to which all others are subordinated. And injustice is considered as a constraint on the freedom to pursue those projects of one's own choosing. And the role of law and government and social life primarily become oriented towards the removal of constraints, public constraints, private constraints, perhaps even natural constraints, and otherwise provide the conditions for the assertion of the unencumbered individual self. Now, in some ways, as I said last time, this is a very attractive vision of human identity and flourishing, especially to Americans. The idea of the solitary individual will bestriding the world around him or her, imposing his or her will on the world around them, imposing his or her will on one's own body, to make one's body into an instrument, an effective instrument of one's own interior vision of what my life is or should be. It's a very attractive kind of view. Unfortunately, it turns out not to be true about most human beings, especially in light of the arc of human life, which begins in total dependence upon one's parents. And if everything goes according to plan, as we hope it will, a gradual and gentle rise in one's agency and power, to the point perhaps when we can impose our will on our natural surroundings, on our circumstances to pursue our hopes and pursue our dreams. But immediately upon reaching that peak of agency, we begin, again, in the very best possible scenario, God willing, gentle decline towards total dependence once again. And expressive individualism misses all that. It misses all that because it doesn't understand the person to be coextensive with his or her body. It doesn't take embodiment seriously. It doesn't take the entailments of embodiment seriously. It simply focuses in a kind of philosophically dualistic way on the mind and the will as definitive of the person. But that, I argue, is not a sufficient description of the community of human persons, or even any individual human person at certain important stages, maybe most stages in his or her life. Embodiment means we are vulnerable. It means we're mutually dependent upon one another. It means we're subject to natural limits. And what embodied people need for their flourishing and, frankly, for their basic survival is not the conditions to assert their unencumbered will. What people need, what embodied people need to survive and to flourish, are what McIntyre calls networks of uncalculated giving and graceful receiving. That is, networks of persons who are willing to make the good of others their own good without seeking anything in return for themselves. And this is obviously essential for basic survival. We're all here. You can all hear my voice right now or see this image right now because someone, probably your parents, decided to make your good their good without really seeking anything commensurable in return. There is nothing commensurable in return. This outpouring of self-sacrificial love of parents toward a totally vulnerable child and individual. I mean, we can have certain hopes and dreams, but the truth is we take care of our children not because we are obliged to by contract or not because we're obliged to by some external force, but instead or coercion, but because of the nature of the relationship itself. What it means to be a parent and to stand in a relationship to a child is that you have an obligation to care for that child and to support that child's well-being, simply because that's what it means to be a parent. And as a child, you don't have to earn the right to be cared for and sustained by one's parents. You have that entitlement, that unearned entitlement, simply by virtue of that relationship, of that network of uncalculated giving and graceful receiving between parents and children. And I argue in the book that these networks of uncalculated giving and graceful receiving are not only important for our basic survival and the survival of our species, but they're also important for us to develop into the kind of beings that we are meant to become. That human flourishing is, in fact, developing the capacity to make the good of others your own good. We're at our most human when we are taking care of one another without seeking our own ends, without seeking anything in return. Put in a more concise way, human beings, I argue, are by virtue of their embodiment made for love and friendship. That's what it means to be and flourish as a human being, based on a reflection on what it means to be an embodied being. Okay. And to create and sustain these networks of uncalculated giving and graceful receiving, we have to practice and inculcate and support the virtues of what McIntyre calls the virtues of acknowledged dependence. And I've added some virtues to these. They're not just the McIntyre's virtues from his wonderful book, Rational Dependent Animals, or Dependent Rational Animals. But they certainly are built around that, and they augment it slightly with the wisdom of some other thinkers as well. But the first set of virtues are the virtues of uncalculated giving, just generosity, hospitality, misericordia, and then of course the virtues of graceful receiving. Chief among them is the virtue of gratitude, which engenders a kind of humility, lets us realize that everything is gift, that we in fact didn't earn our own survival. We didn't earn our place in the world. We're here because of the sustained work of others. It should make us open to the unbidden, tolerant of imperfection. Should recognize that we stand in a relationship of solidarity to one another. That we should respect the intrinsic equal dignity of one another. We should be truthful. But fundamentally, all of these virtues of giving and receiving can be understood through the lens of authentic human friendship. Okay. So, and as I've said, expressive individualism misses all that and leads to a variety of pathologies, including, most importantly, the inability to recognize the claims of the weak and the vulnerable, children, the elderly, and the disabled, who are invisible through the lens of expressive individualism. Okay, so that's by way of review. Take that framework, take that analysis, that anthropological analysis, and train it on the jurisprudence of American abortion and what comes to the surface. What do you find? And so the first thing I do in the chapter, and the essential task in the first instance, is simply to describe what American abortion law is. And in some ways, it's very easy to do. It's easier to do in the United States than it is in other countries in some ways. In other ways, not so much, but in basic formal ways, it's very easy to say what the law of American abortion, what American abortion law is in this country, because it is almost entirely a creature of Supreme Court decisions. That wasn't always true. That wasn't true before 1973. That wasn't true. We used to govern ourselves through the political branches of government on the question of abortion. Really since the nation's founding. And then especially there was a flurry of activity in the middle of the 19th century, although common law always had dealt with abortion. I'm not going to talk so much about common law or the flurry of statutory law in the 19th century all the way up to 1973, but we used to pass laws and govern ourselves in the way that our friends in other countries do. In other countries like the UK or Germany or Italy or other countries where there's not a Supreme Court decision that binds everyone to a particular framework on abortion, but rather it's worked out through the political process. And there are interesting sociological consequences of that, namely the issue of abortion in those countries where the issue has been dealt with in those ways. It's less polarized, it's less pressurized, it's less extreme in some ways than we are here in the United States. And I think arguably that's part of an artifact of the Supreme Court, essentially taking the entire question of abortion away from the political branches in 1973 under a very peculiar interpretation of the 14th Amendment, which we can talk about in a moment, and then giving essentially an absolute victory to one side on the contending sides, to the pro-choice side, the abortion rights side, and then leaving the pro-life side, as it's described, to basically focus all of its efforts on ancillary restrictions on abortion, waiting periods and things like that, but primarily focused on American politics, election of presidents, election of senators, and ultimately the appointment of Supreme Court justices to try to undo their perceived harm that was done in Roe v. Wade and Planned Parenthood versus Casey. That makes us very unusual as a country in terms of that being the field of contestation for the question of abortion. And I think it's had very negative, and I'm editorializing now, I think it's had very negative effects on our politics. I think it's had very negative effects on our social relations to each other. And I think it's just getting worse in some ways. So American abortion law is created in its modern form by the United States Supreme Court. Okay. Most everyone has heard of a case called Roe v. Wade, 1973. A lot of people don't actually know what it holds. Social science evidence suggests that people don't know what the holding of Roe is exactly. In fact, some people think that Roe v. Wade was a decision about voting rights or about integration of schools. They just know that it's an important decision, it's an important historical decision, and that people disagree strongly about it. Not many people could state with particularity and accuracy what the holding of Roe is or what it did, which makes the social science questions that Dr. Bouffill started with kind of interesting, because the fundamental question, the moral question about abortion is not the same thing as the legal question about abortion. The legal question fundamentally centers around which branch of government gets to make the law in this space. And the Supreme Court in 1973, in a very surprising decision, surprising even to liberal icons like Ruth Bader Ginsburg or Larry Tribe, that the decision that they took in Roe v. Wade to essentially constitutionalize the question and take it all to themselves in its most fundamental forms was surprising to even those icons of the left. And in fact, Ruth Bader Ginsburg observed that she thought that it was such a sweeping and surprising decision that in some ways it fanned into life the controversies that we see today. That it sort of did too much too quickly. So what did Roe v. Wade do exactly? Roe v. Wade holds that the 14th Amendment's due process clause, which is the clause that states that no person shall be deprived of life, liberty, or property without due process of law, ratified in 1868, by the way, at a time when abortion was illegal essentially everywhere in the United States. The states that ratified the 14th Amendment, the drafters of the 14th Amendment, the citizens of our republic at that time in 1868, nobody thought, if you'd asked anyone anywhere in the United States, do you think that the 14th Amendment due process clause forbids states from regulating abortion? The answer would have been, of course, we don't think that, because they all had laws regulating abortion, in fact, banning abortion. And some states, like the state of Ohio, in months after ratifying the 14th Amendment, tightened its criminal laws on abortion to ban abortion from the moment of conception on the grounds that, and I'm quoting the legislative report, is child murder. Okay. So nobody thought the 14th Amendment in 1868 had anything at all to do with abortion. So the first thing to notice is the Supreme Court's decision in interpreting the 14th Amendment is not necessarily bound to the text, history, and tradition of the 14th Amendment itself. It's a much more dynamic and creative and untethered to those elements kind of principle of interpretation. What the court held was there is an unenumerated fundamental right to privacy, which had been announced earlier in a case called Griswold versus Connecticut in 1965, dealing with contraception, that includes a right to abortion. Now, that itself was contested, right? There are many jurists who would argue that the right to contraception is distinguishable as an analytic matter, as a constitutional matter from the right to abortion, as a moral matter to the right to abortion, and therefore constitutionalizing a right to contraception, in that case, it was the use of contraceptives by married couples, does not entail a right to abortion because they're fundamentally different things. Most obviously, one involves the intentional termination of a developing human life and one doesn't, right? But that's not the only difference. There are also interesting differences in the concept of privacy and how it applies. But let's put that to the side. We can talk about that in the question period if you'd like to. So the court said, again, there's an unenumerated, meaning unwritten, fundamental right to privacy that includes a right to abortion. And all of that is embedded and implied by the 14th Amendment's procedural guarantees of life, of due process. Because the right to abortion was deemed to be fundamental, that meant that it was enjoyed a position of priority within our framework of rights, that it had the very highest degree of protection against state encroachment upon that right, and the mechanism by which courts operationalize that protection is through what's called a standard of review, where they will evaluate any state restriction on the right to abortion through the lens of what's called strict scrutiny, meaning they demand that the state interest at issue in warranting the restriction of abortion in the state's mind is the most compelling interest imaginable or articulable. And then even if the court's satisfied that the state's done that, then they ask the question, okay, if assuming it's a compelling interest, have you pursued that interest via the least restrictive means imaginable? And strict scrutiny almost always results in the state's law or regulatory effort being struck down as a result. Roe v. Wade also said, building on this concept of a fundamental right, strict scrutiny said that the human pregnancy, the state's interest, let's put it this way, the state's interest in protecting prenatal life or regulating for maternal health for pregnant women are not sufficiently compelling at the early stages of pregnancy. In the first trimester of pregnancy, they say that there is no state compelling interest compelling enough to restrict a woman's right to abortion, and therefore the state can't regulate abortion at all in the first trimester of pregnancy. In the second trimester of pregnancy, the court said, and again, something interesting to note here is that there was usually when the Supreme Court takes a case, the case that they take had an evidentiary process below to solve contested factual questions. All right. You have trial by jury where the jury sits as the fact finder and contested questions are brought and litigated by the adversarial parties. And then there's a resolution to those contested questions. And the adversarial process gives us confidence that the answer to those questions are valid. Well, interestingly, because of the procedural posture of Roe v. Wade, there was no evidentiary hearing of any kind below. There was no trial by jury. There was this 3-judge panel in the district court who simply decided the question as a matter of law. So every factual predicate, every factual premise that Justice Blackmun relies on about the safety of abortion, about the history of abortion, about the history of abortion regulation, about the history of conceptions of when life begins, all of that emerged for the first time in his own opinion in Roe v. Wade. None of it was tested by the adversarial process for accuracy or validity, which makes it very strange and also very interesting. So everything he says is a matter of his own, really, speculation informed by his own private research, which is not generally how we resolve contested questions of fact in the law. Be that as it may. And in fact, I'll add, no one in the arguments for Roe at any stage of the litigation ever argued for a trimester framework. Justice Blackmun himself devised the trimester framework. He wanted to, according to his papers, wanted to make it a cutoff at 12 weeks. But another justice, I think it was Justice Douglas, told him that sounds too much like a statute. You should do a trimester framework instead. So he operates this trimester framework. First trimester, no restriction on abortion. Second trimester, because of his views on the relative safety of abortion and childbirth, again, untested by the adversarial process for accuracy or validity, the state's interest in maternal health is sufficient to warrant certain kinds of restrictions on abortion in the second trimester, but you cannot but you cannot regulate for any other purpose besides trying to advance maternal health in the second trimester of pregnancy. It's only in the third trimester of pregnancy, Blackmun argues, that you can actually regulate in the name of fetal health or promoting fetal life, which Blackmun describes as potential life in his decision. All right. In the third trimester, however, you can regulate for those reasons, but you must always include a life exception, exception for the life of the mother in those instances where her life is threatened by the continuing pregnancy. That was true of the Texas law that was struck down in any event. But you also have to include a health exception, which is defined in Doe v. Bolton as any aspect of a woman's well-being, not just physical health, not just psychological or emotional health, but also familial health and economic health as determined by the abortion provider himself, which means that you must always include an exception that includes basically any aspect of a woman's well-being, which leads to and led to, for many, many decades, the invalidation of laws in which any abortion provider could invoke any aspect of a woman's well-being. And that's true up until the year 2000, which we had a case called Stenberg versus Carhart, which we won't talk about, but we can in the question period. So that's basically the framework from Roe v. Wade. What exactly was the anthropological reasoning here? How do we understand the notion of personal identity, human flourishing that underlay Justice Blackmun's decision? Well, as I've already mentioned, the doctrinal mechanism that he used to reason to the conclusion that there's a right to abortion from the procedural guarantee of the 14th Amendment is called substantive due process. It's the idea that some rights are so important and so fundamental and so essential to the just functioning of any system of laws that it absolutely has to be provided, and it cannot be taken away no matter what the procedural guarantees are. Otherwise, the entire system of justice would collapse and is invalid. That means there are certain kinds of unspoken rights in the Constitution that can be vindicated against state action and can override state action. And so the question becomes, and substantive due process is controversial for this reason, how do you find out what those rights are? How do you identify what those rights are? And how do you resist the temptation as a judge or justice to simply import your own policy preferences under the auspices of doing substantive due process? How do you tether yourself to the Constitution in a way that you can be faithful to the text, history, and tradition of the Constitution while at the same time trying to find these unenumerated, unstated rights? Well, Justice Blackmun in Roe v. Wade took a very, as I said, dynamic approach to this question, although he didn't quite explain, I think, with sufficient precision what his thinking was as to how he got this very important right to abortion out of this through this process of discerning unstated meaning in the Constitution. But we can see where the right comes from when we focus on his discussion of the competing interests of the mother and of the state. Okay, so it is in the discussion of the burdens of unwanted pregnancy, not just pregnancy, but parenthood as well. Not just the physical burdens or even the psychic, emotional, or financial burdens of a pregnancy, but also the burdens of unwanted parenthood, the stigma of unwed motherhood, the problem of bringing a child into a family that can't care for that child, or that doesn't want to care for that child. These are all things that he specifically articulates as the burdens of an unplanned pregnancy and parenthood that all must be considered when discerning whether or not there is a fundamental right to abortion, unwritten, implied by the 14th Amendment due process clause under the auspices of due process. Okay, so he sets out the competing burdens. He says a woman who's facing an unplanned pregnancy is confronted with these, and this is obviously true, right? She's obviously confronted with extraordinary burdens that fall distinctively on her shoulders to carry that child to term. But then he doesn't stop there. He says, and even after the child is born, there are terrible burdens that not just the mother, but the family and even the community have to bear in order to protect and to promote the flourishing of that child. These are all the burdens that he cites that come with an unplanned pregnancy. So you see how he's framing the question as a conflict of interest between the mother and the state, which is representing the interest, of course, of its own interest. One of which is probably the most fundamental of which is the interest in protecting the life of the prenatal organism in utero, the unborn child, the fetus, however you want to describe it. Okay. And what Blackmun says is these burdens are so significant. These burdens of unplanned pregnancy and parenthood are so significant that they overwhelm the state's interests in prenatal human life, which they call potential life, as well as interest in promoting the health of pregnant women, or securing the health of protecting the health of pregnant women. So he says, in light of this narrative of conflict. In light of this burdens on the mother versus the interest of the state, he emerges from that comparison the notion that there must be a fundamental right to abortion, and the state may not adopt one theory of life and override the rights of the pregnant woman at stake because of the consequences for her and her family and the community that would follow from that. Now, let's take a step back and ask a question about what anthropology is responsible for this framing of the issue itself. First of all, what's the normative frame? The normative frame is privacy. The normative frame is the right to be left alone and to reject unchosen burdens imposed by others, by the state adopting one theory of life, by the burdens of the unborn child imposing as a kind of unwanted intruder into the body of the mother. And the narrative of conflict between mother and child represented by state is a narrative of conflict. It's a conflict of atomized individual strangers. Mother and child are strangers. They're contending for the scarce bodily resources of the pregnant woman, who is a person, who is indisputably a person. And then the court, although it claims to be agnostic on the personhood of the unborn child, adopts a rule that forbids the state from ever treating the unborn child as if it was a person. So it declares implicitly that the unborn child is subpersonal. So you have two strangers fighting over scarce resources, the mother's body and future, one of whom is indisputably a person, the other of whom is a kind of invading stranger that occupies a subpersonal status. The relationship is defined by will and choice. There's no recognition at all of the biological relationship or the normative relationship between mother and child. The definition of health, as driven by Adobe Bolton, turns out to be any aspect of well-being, including familial and economic goods, as defined by the abortion provider. And so that's the beginning of the anthropology. So it's not surprising that the solution that Blackman provides and his colleagues provide in Roe is a kind of right to use lethal violence in order to defend one's own autonomy and one's open future. And the court sort of doubles down, if you will, on this anthropological set of premises in Planned Parenthood versus Casey in 1992. It was a challenge to Pennsylvania's Abortion Control Act, which included, as I say, side constraints on abortion, like informed consent provision, a 24-hour waiting period. There was a parental involvement rule that required the involvement of one of the parents or both of the parents when possible to secure consent for the child to get an abortion. And then also there's a spousal notification provision. It was a 5-4 decision. The court declared that it was reaffirming what it called the core holding of Roe v. Wade, because there's a protected liberty interest, notice the jettisoning of the word privacy with the word liberty, in obtaining an abortion, and by virtue of the prudential doctrine of stare decisis, which has nothing to do with well, that's not true either. I was going to say there's nothing to do with the underlying moral question. In fact, does have a lot to do with that. We'll talk about that if you want to. That's not really essential to assessing the fundamental anthropological question that I'm going to be talking about, although we could if there's time and if people have interest in the question period. But let me just very briefly state what the new rule in Casey is. The new normative justification for abortion rights in Casey is liberty, not privacy. It's a protected liberty interest instead of Roe's fundamental right. That's a dramatic change, at least in the language of the nature of the right itself. The court in Casey abandons the trimester framework in favor of a pre versus post viability binary rule. It abandons strict scrutiny in favor of what they describe as an undue burden standard of review for pre-viability abortions. The bottom line is this: Planned Parenthood versus Casey holds that because a woman has a protected liberty interest in obtaining an abortion, for reasons that I'll explain in a second, and because principles of stare decisis, which is a prudential common law principle that says if you're going to overturn a past decision because it was wrongly decided, you should consider the consequences of doing that, whether or not it would be too destabilizing of law, whether or not the doctrine that you're considering overturning is unworkable or not, whether or not there have been subsequent changes in facts or law that make it unsustainable. It's a series of prudential questions that the justices ask themselves in discerning whether or not whether they should, in the name of the good of preserving stability and transparency and predictability in law more generally, whether they should disturb a prior decision, even if it was wrongly decided. Okay. So the court says prior to viability, the state may not unduly burden a woman's right to abortion. It may not ban abortion prior to viability. It may not impose a substantial obstacle prior to viability takes away from the woman the ultimate authority to make a decision whether or not to terminate her pregnancy. That's prior to viability. But at the same time, the court said the state can adopt ancillary measures like informed consent laws, 24-hour waiting periods, and parental involvement laws, all of which were at issue in this case, which may make it more difficult to get an abortion, but don't ultimately amount to a substantial obstacle or undue burden. Those are okay. And in fact, the court affirmed as constitutional all of those provisions that I just mentioned, when in some previous cases between Roe and Casey, those had been struck down as being a violation of the strict scrutiny standard of review. But Casey meant to make it more permissible to have those ancillary side constraints. After viability, Casey says, states may restrict abortion in the same way you could in the third trimester of Roe, subject to the life exception that I mentioned before, as well as the health exception. Now, turns out this health exception, because it's so capacious and broad, essentially swallows the rule in the sense that any time an abortion provider asserts that a woman needs an abortion in the interest not just of her physical or emotional health, but also economic or familial health, the law gives way. And that we saw that in a very dramatic fashion in 2000 in Stenberg versus Carter, and Justice Kennedy, who was one of the three judges justices in the plurality of Casey, was in dissent in that case and felt that would have been a complete miscarriage of what Casey had tried to provide. But his other two colleagues, Justices O'Connor and Souter, disagreed. They were in the majority, the 5-4 majority in that case. We can talk about that later if there's time. But in any event, the point is, the bottom line is they replace the trimester framework with the pre versus post viability undue burden analysis. Now, but I think, and as I said a moment ago, they did double down on the question of the anthropology, on the issue of what vision of the person of human flourishing is driving the reasoning in this case. Blackmun relied on a particular framing of the human context rooted in expressive individualism that to produce the rule that he produced, namely the right of one of the two contending parties to use violence against the other to try to defend her interests, or her interest in privacy, her interest in avoiding those burdens that he enumerated. In Casey, it's a little bit different. Again, the pivot from privacy to liberty makes it even more clear that this is an embrace of expressive individualism. These are quotes from the opinion itself. What is driving Justice Kennedy and his colleagues in this opinion? The freedom, and what's the most important good to be vindicated? The freedom to define one's own concept of existence, of meaning, of the universe and mystery of human life. The freedom to organize intimate relationships and make choices that define women's views of themselves and their place in society. The freedom to make choices based on a woman's own conception of her spiritual imperatives and her place in society. And most importantly, the freedom to pursue one's self-defined economic and social future on an equal footing with men by rejecting the unequal burdens of pregnancy and to destroy the intruding stranger that the fetus represents. It is about pursuing one's open future as defined by the self, and to participate freely and equally in the economic and social life of the nation. And to have an essential mechanism to do that is to use abortion to unburden oneself of the unique burdens of pregnancy that fall on women's shoulders uniquely in the event of an unplanned or unwanted pregnancy, whereas men can at least physically walk away from the pregnancy. Women don't have the freedom to do that absent a right to abortion. So goes the argument. Okay. Now, the world of Roe and Casey are a world of expressive individualism and all that means in terms of the loneliness and the strife that entails. It's a realm of strife and conflict among strangers, atomized individual wills. There are no unchosen obligations or unearned privileges. Natural givens are not an aid to interpret the world of physical reality. The person is a lonely agent of desire, defined by the will and the capacity to make choices whose flourishing is in the pursuit of the economic and social aspirations that she decides and she chooses. So it's not surprising that the unborn, given the privileged status of cognitive activity in defining human flourishing, that the unborn child is deemed subpersonal. Now, there's no explicit theory of personhood in these cases, but the valorization of the will and of choice and of decision-making is so front and center. It seems pretty a clear inference that it's unimaginable that a being that's incapable of that kind of cognitive flourishing is even to be inside the moral and legal boundaries of the human community. And therefore, again, as I say, it's not surprising that the right to lethal violence is the fundamental right essential to pursuing these interests. So what's missing from Roe and Casey? Any reflection at all on the meaning of parenthood, starting with mother and child, the network of uncalculated giving par excellence, the parent-child relationship. Any discussion at all of the sui generis nature of human pregnancy. And the womb is the first locus of belonging for every human being who has ever lived. There's a wonderful feminist thinker, Sidney Callahan. Those of you who might be familiar with her. Let me just read what she said here. She's a psychologist, feminist, Sidney Callahan. She says, the abortion dilemma is caused by the fact that 266 days following conception in one body, another body will emerge. One's own body no longer exists as a single unit, but is engendering another organism's life. This dynamic passage from conception to birth is genetically ordered and universally found in the human species. Pregnancy is not like the growth of cancer or infestation by a biological parasite. It is the way every human being enters the world. And there's no discussion, there's nothing like that at all mentioned even in passing in the Roe v. Wade decision or in Planned Parenthood versus Casey decision. The human context is abstracted from that biological reality and replaced by a kind of narrative of contending wills in a universe of strife. There's no discussion of the complexity and risks of dividing the world of human organisms into persons who bear human rights versus non-persons who live at the sufferance of others based on their interests and desires. And most worrisome of all, there's no discussion at all of the possibility or the necessity of human beings, however you want to describe it, depending on networks of uncalculated giving and graceful receiving, in which refuge might be sought by those who find themselves in a crisis. So let me just finish very briefly. I've been going on for too long, but let me finish very briefly by talking about how we might fix this problem. These problems that artificially define the conflict and pit mother and child against one another as strangers in a universe of strife with zero-sum conflict again in battling for the scarce resources of the mother. It's like two people battling over a life raft, or Judith Jarvis Thompson has some very famous analogies, I think, which actually don't work because they also don't take seriously the relationship between parent and child or the nature of human procreation. So how can we fix this problem, right? We can reframe the human context of abortion within an anthropology of embodiment. We don't describe what's happening as a world of atomized strangers locked in a zero-sum struggle with one another, but rather as a crisis involving a vulnerable mother, a vulnerable child, a vulnerable family, maybe a vulnerable community, members of the human family. And our imperative, and think about it for a minute, if you and I were to hear a story about two strangers fighting over a coat in a winter storm, or fighting over a cabin in a blizzard, who gets to be inside the cabin, who doesn't get to be inside the cabin, we would ask questions like, well, who does the cabin belong to? What was the behavior of the two parties before? It would be a very arm's length kind of cold legalistic analysis. And we'd reason to the conclusion, whether or not the person who doesn't own the cabin can, through the doctrines of necessity and private necessity, occupy the cabin temporarily while he seeks to preserve his or her own life, right? Those are the kinds of questions we ask in those kinds of disputes. We don't ask those questions if someone were to say to you, there's a mother and a child in crisis who need us. We don't ask who belongs to what or property. We don't view it through the lens of property and those kinds of questions. We rush to their aid. Any decent human being rushes to the aid of a mother and a child in crisis. And we rush to their aid by surrounding them and embedding them more deeply in the network of uncalculated giving and graceful receiving on which we all depend for our survival and flourishing before, and this is really important, after the child is born as well. Okay, this is not simply a matter of making sure the child gets born and then walking away. This is a matter of caring for mothers and children, families, fathers, families, communities in a way that is befitting of our unchosen obligations and our unearned privileges, which we all hold with respect to one another by virtue of our common membership in the human family. Our imperative is to come to the aid of that mother and child. And those imperatives radiate from the center of the relationships that those individuals have in their family, their community, and their state, and their nation. And the law and the government should play a role in this as well. And the role of the law is to facilitate by a panoply of available means. I'm not settling on one particular mechanism of the law, but pursuant to a panoply of means of encouragement and deterrence and in some cases, making space for private ordering, for civil society to help us to care for one another. But by whatever panoply of available means the law has at its disposal to facilitate the building and sustaining of these human networks, and when help, support, and protection are not forthcoming, to provide it directly. The success or failure of the law of abortion, in my judgment, as I'm arguing now, through the lens of the anthropology of embodiment, is measured by how well or how poorly it sustains these networks of uncalculated giving and graceful receiving and caring for mothers and babies, born and unborn, their families, and the communities in which they live. That, to me, is how we should reorient our thinking about this question. And I have to say, and this is a sort of final point back to the nitty-gritty of the concrete nature of the law, the only way that's possible for us to care rightly for one another through all the mechanisms we have available is for the Supreme Court of the United States to restore to the American people the authority to govern ourselves on matters of abortion, which it's usurped through its jurisprudence pursuant to a spurious interpretation of the Constitution, not rooted in its text, history, or tradition, and following, I argue, an incoherent and novel application of stare decisis. It's only when the court will let us govern ourselves, as our friends in other nations around the world are permitted to do, and we were permitted to do prior to 1973, that we will be free finally to care rightly for one another in all the ways that we all owe and deserve. So thank you very much. And that was a long talk, but I'm happy to have conversation now.
Thanks, Carter. That was fabulous. Thanks for the time. We do have some time for questions, and we have a few questions in the Q&A. Please feel free, if you have a question and haven't submitted it, please go ahead and submit now. So Carter, someone asks, can you discuss the conflict between disability justice and reproductive liberty in relation to selective termination when disability diagnosis is predicted?
Absolutely, that's an essential question, and one of the principal virtues that we should have to embrace and practice, as I described, in terms of the virtues of acknowledged dependence, that flows from the virtue of gratitude and the realization that we are only here because of the sustained efforts of others. And as Alistair McIntyre says, every single human being in his or her life exists on a scale of disability. Okay. Some of our brothers and sisters are more disabled than others, or suffer from greater disabilities for longer than others do. And the good of just generosity dictates that we give to others according to their need, not according to what it can do for us. But the virtue that most occurs to me in response to the excellent question is the virtue of openness to the unbidden and tolerance of imperfection. And we're going to talk a lot about this when we talk about assisted reproductive technologies next time. But to think about what a child is, and to think about what it means to be a parent, is to welcome another being. Leon Kass says, a mysterious stranger that we welcome and love unconditionally. And a child has to be understood through the lens of a gift that we have to, and the proper posture towards a gift is gratitude, not rational mastery, not trying to reorder the child or even worse, reject the child because he or she suffers from some kind of imperfection that we don't value or that we find problematic. And this has been extraordinarily true in the context of abortion for babies who are diagnosed with disabilities in the womb, especially babies with Down syndrome. And it seems to me not coherent with the good of uncalculated giving, graceful receiving, openness to the unbidden, caring for one another the right way, to pursue a regime in which the weakest and most vulnerable among us are systematically eliminated because they suffer from a particular kind of disability. So I think it's incumbent upon, so an anthropology of embodiment would reject the notion that anyone has to earn the right to live, that anyone has to satisfy the standards of some other person in order to not be intentionally killed by that person, whether it's in the womb or outside of the womb. And more than that, more than just the right not to be killed, we have an obligation to care for one another. Now, to be realistic, though, caring for children with disabilities can be difficult and frightening. And genetic counseling, my colleague Mary O'Callaghan at the University of Notre Dame has shown in her own research that genetic counseling can in fact instill in the hearts of parents fears that they otherwise might not have had about caring for the child, and understate or even not state at all the unbelievable gifts that all people, but including especially disabled people, bring to those around them, and the kind of beautiful lives that these children have. And so there's a kind of, it's not surprising that a significant percentage of unborn children are eliminated in the womb because they've been identified as having disabilities, especially Down syndrome. Why countries like Iceland say we're going to eliminate Down syndrome entirely, 100% elimination of Down syndrome, but what they really mean is eliminating unborn children who have Down syndrome. And that's not the same thing. And so, especially those physicians who are listening, to think carefully about what the art of medicine prescribes for caring for others, and under what circumstances the appropriate desire to cure or ameliorate symptoms can be surrendered in favor of a kind of abandonment of the patient, a willingness to eliminate the patient, eliminate the suffering by eliminating the patient, him or herself. And it's not to say that's not a human temptation. Of course it is. Those of us around people who are confronted with those choices, who are confronted with a diagnosis for their baby that's frightening to them, or they don't know what it looks like, those of us around them have an obligation within these networks of uncalculated giving and graceful receiving to come to their aid, to make to let them know that they're not alone. They're not alone in caring for this child, that we're in whatever ways, great and small, in terms of individual interactions or even grand public policy, we have to work hard to make it easier for people to choose the right thing for their children, and to welcome their children as gifts, to love and welcome unconditionally. So, and there are people who are doing that. They're amazing. Even people who have very difficult diagnoses. There's perinatal hospice. There's all kinds of extraordinary, concrete ways in which we can care for one another and care for moms and dads who are terrified of a child's disability that they're carrying in the womb, who might consider it better, all things considered, to eliminate that child preemptively.
Thanks, Carter. Gabriella asked a question about what prevents, in your opinion, the Supreme Court from taking the perspective that the unborn child is a person, and thus abortion can be outlawed the same way murder is, or that the due process clause requires that due process be necessary before an unborn child's life can be taken, akin possibly to the death penalty?
So it's a great question. It's also a great question because it should remind us that what the court was purporting to do in Casey and Roe and all the other abortion cases was to interpret the Constitution, right? We can forget that. We can imagine what they're doing is making law and policy, and we evaluate it based on whether we like the law and policy that they're making. Oh, well, if one's in favor of abortion, maybe you like Roe, maybe you like Casey. If you don't like abortion, you don't like those opinions. But in some ways, that's the wrong way to look at what's going on in those decisions. What the court's authority to do is not to make public policy that it likes, or to make law that it likes, or to do politics in a way that it likes. The court's carefully circumscribed role vis-a-vis the Constitution is to interpret it, and to read it, and to understand what it means for actions that the state wants to take now. Do the state's actions contravene the provisions of the Constitution itself? And so interpretive methods of that should be applied, in my judgment, should tether the justices to the text, history, and tradition of the Constitution. You should seek to understand what it actually means in its context, not what meaning you can impose on it based on your own preferences. So the court, in saying that, so why didn't the court recognize the unborn child as a person within the meaning of the 14th Amendment? Because no person shall be deprived of life, liberty, or property, nor deprived of the equal protection of the laws. Justice Blackmun has a very, very conclusory and I think unsatisfying interpretation of the word person in the 14th Amendment. He simply just says, well, where the word person is used in the other context of the Constitution, it really seems to only have prenatal application. It can't really be true that it implies that it refers to an unborn child. Now, it's a very, very thin kind of textual analysis that he uses in service of the outcome that I think that he favored, namely, because he later says if the child were a person under the 14th Amendment, then we would have a problem. You wouldn't be able to have an absolute right to abortion, or a right to abortion that is as broad-ranging as the one that he articulates. The problem is, what does the word person, to the questioner, what does the word person mean in this context? And justices who are inclined to recognize that Roe v. Wade and Casey were wrongly decided in the first instance as a kind of misinterpretation of the 14th Amendment are going to ask the question, what does the word person mean in its original historical public meaning? Okay. What did the word person mean when in 1868, not what was intended by the drafters, but what did a person in 1868 understand that word to mean in the context in which it was articulated, because the law, if it's written down, this is an oversimplification, stands as a bulwark against changes in attitudes and policies and political preferences. The law has to have a consistent meaning. It can't merely be changed by interpretation if it's going to be a genuine bulwark, which is what the Constitution is meant to be, right? When you write law down, it's supposed to be binding. It's not, you can't change it by reinterpreting it later on. So goes this interpretive argument. So sometimes called originalism, justices will ask the question, what's the original meaning of the word person? Now, I think some justices, I don't know about the justices, but there's some originalists in the academic world or in the public world who are themselves, and we'll take the group that believe that Roe was wrongly decided and should be overturned. And in this group, you have people who are also pro-life, people who believe in the intrinsic equal dignity of unborn children. There's disagreement among these pro-life originalists about what the word person means in its historic sense, whether it in fact meant unborn children or included unborn children, in which case you would have to say that the state could not permit abortion unless it did so in a way that comported with the protections we accord to other human persons. Okay. Now that doesn't mean there would be no abortion, because we allow intentional killing of one private person by another private person in the law all the time, pursuant to excuses and justifications and principles of necessity. The most obvious example of an excuse is the justification of self-defense. Right. So it's not true that the Equal Protection Clause prevents people from using self-defense to protect themselves from one another. So that's just one example of the use of private violence, which is permissible, lethal private violence, which is permissible even among individuals who are recognized as persons by the 14th Amendment, according to the 14th Amendment. So it's not as simple as saying abortion is outlawed if unborn children are persons. It means that the world just got a lot more complicated in a way, because we just have to understand the context of abortion as a proposed use of lethal force by a mother against a child, and we'd ask whether or not it's justified under principles of justification, necessity, and excuse, the way we would in any context in which lethal force is on the table. Okay, but there's real disagreement between scholars, pro-life originalist scholars, about whether or not the word person meant unborn children or it didn't. And if you conclude that it didn't include unborn children, I think I don't, and this is a projection based on no inside information at all. It's strictly my own observation from a distance with publicly available information that everybody has available to them. I would be very surprised if the Supreme Court found, or if even one justice concluded, that the word person, as originally understood in the 14th Amendment, included unborn children. What I think is going to happen, what I predict will happen, is the court will strike down Roe v. Wade and Planned Parenthood versus Casey on the grounds that the Constitution leaves the abortion question to the political branches of government. And the political branches of government can ban abortion, can fund abortion, they can do whatever they choose to do through their political process. Now, question for another time is whether or not that is a satisfactory result, or whether the result is, whether that would also be true of any instance in which the political branch is observing the procedural safeguards of the Constitution, decided to take, maybe even including the amendment of the Constitution itself, decided to write some element of the human family out of the circle of moral and legal community. Could we, for example, exclude people with blue eyes from the community of persons if we amended the Constitution to do it? Like, would that be okay? And that presents very serious questions, I think, as to what stops us from doing that. Would that mean the regime would be unjust and illegitimate, and the regime itself would have to be dissolved? That's an interesting question, but I don't mean to get so afield of your questioner's query. The short answer is it's a disagreement about the historic meaning of the word person in the 14th Amendment. And I think it's unlikely that any justice sitting on the Supreme Court right now would take that view, although my colleague John Finnis and Robert George at Princeton University filed an amicus brief in this case, arguing with, by reference to the historical record, that in fact the word person does include the unborn child or anyone who is a living member of the human species.
Mm-hmm. Thanks, Carter. I'm going to prioritize a couple questions from students. So JP is a second-year law student, it appears, at Notre Dame, and JP has a question. Is the current landscape of abortion jurisprudence a product of expressive individualism solely, or a product of human concupiscence more generally? Put differently, even if we combat expressive individualism in the fabric of American life, will we simply be putting out one fire to have another arise in whatever quasi-liberalist philosophy is adopted by the body politic? Is there a Western philosophy that can avoid the pitfalls of individualism?
Well, that's a big question, obviously, and something worth pondering. I think it is the case that the problem, the root of the problem with Roe and Casey, is a conception of the human person that is rooted in expressive individualism. I think that is an anthropology, I said before, that is especially popular in the United States. It's fed by, in some ways, a particular reading of our history, a particular reading of the political theorists, of certain political theorists who believe that, that which in a way that's coherent with that particular worldview. Although the individualism of, even according to those who might have that view, the individualism of Locke and Smith and others, Hobbes, is not expressive individualism. It's what Bella called a kind of utilitarian individualism. It's a system of well-regulated individuals pursuing their own interest in a way that is ostensibly going to maximize the greatest good for the greatest number. And that it seems to me is different from the problem at the root of Roe and Casey. But as to the larger question, is there a sort of theory that can save us from all of these bad perils and risks? I think it's a longer conversation. And being as you're at Notre Dame, I would encourage you to take Patrick Deneen to lunch and to maybe include Professor Philip Munoz, who have very strong disagreements on this exact question that you're raising. And Professor Munoz has a vision of the human founding, of the American founding, that I think is quite different from Professor Deneen's. And you would benefit, as we all do, from listening to those very thoughtful individuals discuss amongst themselves their competing theories.
I guess the highlight of being, one of the highlights of being at Notre Dame is you can just take folks like Patrick Deneen to lunch on a whim. Super. So we also have a question from Jessica Giles. Jessica is a fourth-year medical student at Vanderbilt who's hopefully matching into internal medicine or family medicine in a couple months. Jessica, hi. Right. Her question is, how does the perspective of embodiment enlighten the question of what to do when the life of the mother is at risk due to the pregnancy? Yeah, no, that's in some ways it relates to the question we were talking about before. I mean, that is the, in fact, I talk about that very specifically in chapter 3. What we have to do in a circumstance in which two individuals are locked in genuine vital conflict like that, is we have to do our very best to take seriously all of the interests at stake and to do everything we can to care for everyone. There are certain kinds of limits that we might impose on interventions that we could make consistent with the larger goods and the larger framework that we've been talking about. But we might as well just go ahead and read the passage, actually, rather than trying to paraphrase it from memory. Let's find it here. It's on page 183. In those tragic circumstances where the continued pregnancy constitutes a grave and proportionate risk to the mother, the law should deploy the familiar legal concepts developed to govern the use of potentially lethal force against innocent persons who pose threat to others. More specifically, the matter should be framed as a conflict between mother and child, working out how the American legal doctrines of justification, excuse, necessity, and related concepts as proportionality, unjust aggression, and the like would apply to the wholly unique context of pregnancy would require a great deal of fact-intensive analysis and reflection to answer it responsibly. Such an inquiry is beyond the scope of the book, but must be undertaken in the future to flesh out the concrete entailments of a public bioethics rooted in an anthropology of embodiment. But the fundamental point here is that the crisis of unplanned or unwanted pregnancy, including in the tragic circumstances we're talking about, need to be viewed through the normative categories of mother, child, father, family, community, and polity, including the government. And, when you're dealing with a situation in which one person is posing a threat to the life of the other, what we could do better than what we're doing now is to actually give the appropriate weight to all the competing interests. What we do now under the abortion jurisprudence is to say you have one person who's making a choice to preserve her own life and future versus a non-person
who has no standing at all in the moral and legal community. That, to me, is not an adequate description of that tragic situation. The tragic situation involves two human beings, a mother and her child, whose lives are intertwined and fates are intertwined in a tragic way. And we start there, and then we start to reason about proportionality and necessity and what's permissible, what's, and what's not, how to best to care for everyone involved. And are there circumstances in which you can use deadly force to save one person from the threat posed by an innocent second person, right? That's the question. And I think we can, the anthropology of embodiment can sharpen the question for us, can bring into relief what it is that we're talking about, and to allow us to reason more transparently about the competing goods at issue in that particular, thank God, rare tragic circumstance.
Thanks, Carter. We have a question from a medical student here at University of Michigan, Emily Roney. Emily says, as a medical student in Michigan, I am concerned that if the right does not legally solely rely with the mother to decide whether or not to terminate a pregnancy, this will result in an undue loss of life as a result of unsafe back alley abortions, as was the case prior to Roe. Are you proposing that the right should solely rely with the mother to choose what to do? Do you agree this should be a question for the state governments?
So the good news is and Bernard Nathanson is a man, a very interesting and somewhat tragic figure. He was one of the founders of NARAL, and he had a conversion to Catholicism. He did over 30,000 abortions and had a conversion to Catholicism. And when he became active in the pro-life movement, discussed a lot of the tactics and narratives and techniques used by him and others when they founded the National Abortion Rights Action League, NARAL. And one of those narratives that they pushed was this notion of back alley abortions and the numbers of back alley abortions, and this is to suggest that they needed a narrative that would persuade well-meaning people to be very hesitant to ban abortion out of fear that there would be this underground abortion situation where women would harm themselves by desperately seeking an abortion. And it turns out, he said, according to him, that it was simply a fabrication. The orders of magnitude of the deaths involved were a fabrication. And interestingly, Leanna Wen, former president of Planned Parenthood, made a comment about these back alley abortions. And the Washington Post itself, which is not a pro-life newspaper to say the least, corrected her statement about the back alley abortions, the order of magnitude of the back alley abortions. So that's an important sort of background fact to straighten out before thinking about the interesting question that you raised. Was there a public health crisis involving back alley abortions prior to Roe? There's very scant historical evidence for that proposition. Okay. Moreover, abortion is much safer now than it ever has been with the introduction of antibiotics and different kinds of techniques. The notion that it would be dangerous for women to obtain an abortion because it would be impossible to provide an abortion in a manner that is safe for the woman seeking the abortion seems to me to be an unrealistic assumption also in the premise of the question. But more deeply, I would say this: if we are persuaded that abortion is the unjust killing of an innocent human being, and if we are persuaded, and these are big ifs, right? The questioner may not share these premises, and that's perfectly understandable. A lot of people don't, as Joe pointed out. If the polity concludes that abortion is the unjust taking of a human life, and therefore must be banned or prevented in some way through the use of the law, and I would hope that a polity who would make that conclusion would also adopt all of the mechanisms to support mothers and families in crisis, both during their pregnancy and after their pregnancy. And thankfully, we're seeing some of that right now emerge in some perhaps unlikely places. The state of Texas just adopted a $100 million policy to care for mothers and babies in need before and after birth. There's a proposal in Congress, which is co-sponsored by several different sort of high-profile opponents of abortion, to provide support and care for mothers and children in crisis, and to strengthen the rules on child support for deadbeat dads who to honor their obligations to care for their families. Putting that to the side, though, if we conclude as a polity that it's important to protect innocent human life, the consequences of illegal efforts to take that innocent human life might have collateral consequences is, at least in other contexts, not ever a consideration that would prevent us from protecting that life in the first instance. There was the idea that that certain kinds of crimes of violence, if restricted by the law, might find their way into other communities and endanger other people, generally don't lead us to the conclusion that we shouldn't criminalize those crimes of violence. What it leads us to do is say we need to take measures to prevent those collateral side effects that we're worried about, right? Making sure that women don't, if they find themselves in a situation where they seek an illegal abortion, that they can receive emergency medical care immediately and to be treated and cared for in the way that they and all of us deserve as well.
Thanks. Well, friends, we have come to the end of our time together. I'm so sorry we didn't get to a lot of good questions from teachers and other students, but please join us for the next couple sessions. So for just on your calendar, our next session will be Tuesday, March 8th, also at 7 o'clock Eastern Standard Time. And the subject, as Carter said, will be anthropology and technology, utility and assisted reproduction. And if you just can't wait until then to hear from us, consider registering to hear me and Carter and Professor Charles Camosi from Fordham talk about bioethics on a panel this Thursday night at 8 p.m. on Zoom for Notre Dame's McGrath Institute Conversations That Matter series. Registration and information can be found on Notre Dame's McGrath's website. And as a reminder to our U of M students and trainees, if you'd like to chat more about this topic or any other topics we are covering or anything else for that matter, please reach out to me. Always happy to talk to anybody. I'll see you next month, friends. God willing. Carter, thanks. Joe, thanks. And for all of you to be here, thanks so much. Good night.
Thank you all. Good night.